tickled to have you. So before we begin our discussion on today's topic, let me provide a little background. Our audience today is a mix of existing clients and folks new to our firm. For those just joining us, let me provide a little background of who we are and what we do. Fort Pitt Capital Group is a holistic wealth management firm. Currently, we manage $5 billion for foundations, corporations, and affluent individuals. We feel we're a great size. We're large enough to gain attention, yet small enough to create customized and personalized financial strategies for our clients while providing excellent customer service. About our webinars. We want all our clients to understand that we are not just your financial advisors. We are a holistic resource for you. So when you have needs, not just investment planning or retirement planning, but you're looking to buy a house, you're trying to decide whether to buy or lease the car, you're trying to plan for your child's or your grandchild's college education or educational expenses, please bring those topics to us. That is what we do. That's what we're here for. So we are that resource for you, and we want to be that resource for you. So a little bit about us before we start. My name is Daryl Patten. I'm a financial advisor and consultant here at Fort Pitt Capital. I've been with the firm now for 22 years. Prior to coming to Fort Pitt, I was with Charles Schwab and Company as a senior sales director for 14 years. So I bring 36 years worth of experience to the table, and hopefully we can share a little bit about that experience with our clients today. So Cory, I'll let you introduce yourself.
Sure, thank you, Daryl. My name is Cory Phillips. I'm excited to be here. I started working with my first client about 7 years ago, March of 2017. It's crazy how fast that goes. I am a certified financial professional. That's just a designation that you get in the industry for passing a test and going through education requirements. I got that in 2022, and I've been with Fort Pitt for about 3.5 years, or almost 3 years, sorry. I do like being out in the community, spending time, being active, playing sports, being with friends and family, and I am from the South Hills of Pittsburgh here. So thanks for joining us. Kicking that over to Ken. Ken, can you introduce yourself?
Thank you. Yes, Cory. And again, my name is Ken Ventresca. I'm an attorney. I focus in the areas of taxation and estate planning and advising small to mid-sized businesses. I've practiced in Pennsylvania since 1992 and the state of Florida since 2011, and I'm very happy to be here today. Back to you, Cory.
Thank you. So just some quick housekeeping items for everybody watching. If you're on a device, whether it be an iPad, an iPhone, whatever it is, there should be a questions area. So this big area, arrow on the screen pointing to questions, you can go in there and type them in and submit them. On a desktop or laptop or a computer, we have this red area where I'm hovering my mouse over right now with this yellow arrow. If you click on the red arrow, it should pop out or decompress your screen. Whenever you pop it out, there's two areas. One's handouts. There's one in there that just shows more about what we do. And the lower area, questions. Again, you can type them in and submit them this way. What we're going to try to do throughout the webinar is address your questions as they come in. We'll have a little Q&A at the very end to answer questions too. If we don't get to your questions, we will be following up with answers at the end of the webinar. So Daryl will speak to the upcoming webinar, and then we'll begin.
Yes, before we start, we do have another webinar scheduled. The title of that webinar is Smart Inheritance, How to Keep Wealth in the Family. Ken will join us for that webinar as well to be our guest speaker, and we will drill down into a lot more detail on some of the topics that we hope to cover today.
Great. And I will close down the PowerPoint presentation for now and open it up so you can see us more. It's going to be a conversational format. Again, Daryl will be the facilitator, and without further ado, Daryl, you want to get us going with the meat and potatoes?
I sure will. So let's begin. Our first question, and I'll ask both of you for input, is what happens to your assets when you pass without a will? Cory, can you address specifically what happens to your investment accounts?
Sure. So your investment accounts, if it's a single account that's just in your name, the state will actually determine and dictate what happens. So there's a certain set of parameters the state follows. First, it goes to your spouse, and then there's rules beyond that that Ken could speak to. If it's a joint account already, and you're on a joint account with your spouse or with your kids or something, the assets will pretty easily transfer to them. But look, if you don't have a will, we would emphasize the importance in getting one. It just helps outline where things go. Now, we do highlight the importance on beneficiaries. If you don't have a will, but you do have beneficiaries on your accounts, it really helps get your assets to the right places. So say you have an individual brokerage account and you have a beneficiary on there, your assets will go right to that individual or individuals. On the brokerage side of the house, for individual account, they call it a transfer on death. If you have a bank account, they call it a payable on death. If you have an IRA or 401k and retirement plan, they just call it a beneficiary. It's all financial jargon, and it all really means beneficiaries, and it gets your money right to that person, and it supersedes the will. Anything from a broader standpoint, I guess, that you want to add to that, Ken, or on what I just mentioned?
Yeah, just to touch on what you had just said. You said it supersedes the will. That's not generally known, in the sense that if a person has, for example, I've done many estate plans. I've reviewed many estate plans. They've done wills and they've done trusts. And they put all this time and effort into getting them drafted and very, very detailed as to where everything goes. But when I review the plan, I realize, well, wait a minute, nobody bothered to look at the assets. Like you said, Cory, whatever those beneficiaries are, transfer on death, payable on death, whoever those are, they get it first. In other words, they get it instead of how it goes through the will. So if you have a beneficiary on a retirement account, that beneficiary will get the retirement account regardless of what the will or trust that you've drawn says. So back to Daryl's question, what happens to your assets when you die? The answer they teach you in law school is it depends. It depends. First of all, are there beneficiaries listed? Like Cory said, if there's beneficiaries listed, they get it, right? If there's transfer on death, payable on death, they get it. But if there's not, if the asset's only in the deceased person's name alone and there is no will, then it goes through a system called probate. And we're going to talk about the probate process in a bit, but basically you have no will, so the state has drawn a will for you. And Cory talked about this before, where it's this, it's like an if-then. It's like we take a snapshot when you die, which of your relatives are alive, and there's a certain pecking order to these relatives. Spouse generally comes first, and then kids. If not, then it would go to grandkids. If not, then the parents and grandparents, and then to siblings, and then to aunts and uncles, nieces and nephews, and eventually it gets out to the Commonwealth of Pennsylvania. It'll find a taker, even if the Commonwealth of Pennsylvania is your heir in your unintended will, which is the intestacy code is what that's called. So yeah, we want to be sure that right out of the gate, what happens to your assets when you die, at minimum have beneficiaries listed to get those assets at minimum. In a good scenario, you would have a will or other estate planning device prepared so that these assets can pass in an orderly fashion.
Great. We've kind of danced around the topic or the actual term a little bit, but when someone passes without a will, there's actually a term for that, right?
Yes, intestacy.
Intestacy. So
Correct.
if you pass without a will, intestacy. So if you use that term or we allude to that, meaning going forward in our webinar, everyone will know what we're talking about.
Yeah, the intestacy code is the will that the state of Pennsylvania, the Commonwealth of Pennsylvania, and pretty much every other state has drawn for its citizens. So again, you have no control. It's just whatever the state has deemed to be the next taker. Which brings us sort of to the topic of like, what is probate? Because we're talking about probate here. Probate is the system by which your assets are distributed at your death. And when I say assets, I mean assets with no beneficiary, no joint owner, no payable on death, no transfer on death, just your name alone. Those assets and only those assets are what go into the probate system. And the probate system is basically, it's one or the other. It's either you go through the probate system with a will, which is a tested, T-E-S-T-A-T-E, a tested administration, or you go through without a will, which we had just discussed as an intestate administration. And again, intestate means no will, means the intestacy code determines who gets your property. A will, you determine who gets your property. And again, the probate process is, the will, it directs where your assets go in the probate process. But again, they're only assets with one name on them, no beneficiaries, no joint ownership.
So right now, we're talking about assets and stuff.
Right.
What happens to debt? So if someone dies and has debt, whether it's an existing mortgage or loans, car loans or whatever type, what happens then?
The probate process, whether it's tested with a will or intestate without a will, there's really four things that happen. The four purposes of going through probate. One is to gather your assets. A person dies, let's just say they have a will. They have a will and the will directs where the property goes. Well, the first thing we need to do is we need to go out, we need to get their property, get it marshaled together. In a lot of cases, we liquidate the property to cash to get into the second prong of the probate process, which is paying the debt. The debt has to be settled, and as a result, the executor, the person that's been appointed in the will, or the administrator, the person that is running the estate in an intestate administration with no will, they have to make sure that the debt gets paid, which then brings you to the third aspect of probate, which is paying taxes. Pennsylvania is one of very few states that still has a state level inheritance tax. So when a person dies in Pennsylvania, pretty much everything except life insurance is going to be subject to an inheritance tax. Now that rate ranges from 0% for a spouse all the way up to 15% for nieces and nephews and friends and people of that sort. Now you have a 4.5% rate for children and grandchildren and lineal descendants, and a 12% rate for siblings. So Pennsylvania, that tax has to be paid, and it has to be paid within 9 months after the date of death. Once the debts have been paid, inheritance tax has been paid, all of the other creditors and taxes have been paid, we could then close the estate, which would be the last aspect of the administration, which is to distribute the assets to the beneficiaries that are left over.
Wonderful, wonderful, thank you. So that's a lot of information. Can you just kind of a quick review on when someone passes, the hierarchy of distribution when it goes to beneficiaries, then through the estate?
Absolutely. Yeah, like I said, when we open up an estate, we have to gather the assets. We have to inventory those assets. Again, those are filings that are required by the probate process. And then the debts need to be paid. So we have to get a list of all the creditors, and we have to make sure we can pay all the creditors. And if we can't pay all the creditors, there's not enough assets to go around. There's a pecking order that the probate code provides as to which creditors get paid in which order. For example, the costs of a funeral, things like that, the administration costs, those are higher in the pecking order than a general creditor. After the debts have been paid, we have to file an inheritance tax return, and we have to declare the assets and all the expenses, and whatever the net value of the estate is, we have to pay inheritance tax on that. And then that gets filed, and each one gets reviewed. And once the inheritance tax return comes back approved, because they actually send you a letter, and it says it's called a notice of appraisement, and it comes back in the mail, and it says accepted as filed, or they'll make changes, they'll propose changes. Once that's all settled, then we have whatever assets we have remaining. And if it's a tested administration, we look at the provisions of the will to determine who gets those remaining assets. And if it's an intested administration with no will, then we look at the probate, we look at the intestacy code in the probate code to see who gets those assets as well.
If a client passes or someone passes and they have an account with a transfer on death or beneficiaries named on their IRA accounts, do those assets have to go through probate?
No, again, probate is only when there's one name on the asset. So if it has a beneficiary, the beneficiary, as Cory said earlier, supersedes the provisions of the will. So a lot of times people will set up their estate plan, and like I said at the beginning, they'll do a great estate plan. They'll have a will and trusts, and we'll get into what trusts are in a little bit, but the point is they'll have it all set up real detailed, but nobody bothered to look at how the assets were titled or if there's beneficiaries attached, because again, those beneficiaries or those joint owners, they get the property before it would go through the will, so they supersede.
Wonderful.
Wow.
Wonderful. Cory, question for you. Can you explain the difference between a financial power of attorney and an executor or an executrix?
Sure. Yes. So power of attorney documents are really in effect while someone's alive still, right? So you have to be alive to have your power of attorney work for you. So the financial power of attorney allows someone else to make decisions on your finances. There's the healthcare power of attorney. And on the opposite side of the coin of that is the executor or executrix. That's just the difference between a male or female running it, not to get confused with the jargon. So executor or executrix, those come into play when someone passes away. And those are the folks who will run your estate, and they'll be the ones in charge of administering your will. So it should be someone that you trust and someone that you could see following out your wishes to ensure that, you know, the diamond ring from grandma goes to the right sibling, or, you know, the car gets to the right person, or, you know, this specially knitted item that your grandpa made, or whatever it is, gets to the right people. You want to trust that person. So again, power of attorney is for folks while you're still alive, and I'm sure that Ken can, you know, expound on more details to that. The executor or tricks goes into effect when someone passes away. We do have some questions coming in here. We're going to try to hit some of these here in a second, but from what I just mentioned, anything more in detail on the power of attorney or will that you want to add, Ken?
Yeah, the one thing on the power of attorney that is very, very important to understand, and I think it's the most important document a person can have, maybe short of a medical power of attorney. The reason why is a power of attorney is let someone else step into your shoes. It lets someone else act for you, to sign your name, transfer real estate, open a bank account, withdraw from a bank, close a bank account. Whatever you can do, the person you've named as your financial power of attorney can do for you. Now that's both a good and a bad thing, but let's look at the good side of that for a moment. I see this pop up a lot of time in husband and wife situations, or even in unmarried people where they lose capacity for whatever reason, whether it's a permanent incapacity, a mental incapacity, or it's just they're sick and they're undergoing some procedures and they're basically not conscious or able to give legal consent. In those situations, if a piece of real estate needs to be sold, again, the bank account needs opened, or some financial activity needs to take place, the power of attorney, the agent under that power of attorney can sign the person who's incapacitated, can sign their name as if it's them. Now, the alternative to that, and I think you probably have had this happen before, is when somebody comes to you and they say, well, gee, my husband is unable to sign his name, or my wife's unable to sign her name. Can I sign for them? And you say, well, are you their agent under their general power of attorney? Well, no, he doesn't, or he or she doesn't have one. At that point in time, the only thing that's going to get that signature, to have that signature be legal, is you're going to have to get a guardian appointed for the incapacitated person. Now that's an expensive, time-consuming public process, and it's unnecessary. The power of attorney avoids that, and that's the number one reason why I think anybody that walks into my office or any lawyer's office, at minimum, should walk out with a general power of attorney, because that it puts the people around you in a situation where they have to go through this, expensive court proceeding to get a guardian appointed. If you do not have a person, an agent appointed that can sign for you during periods of incapacity.
Gosh, there's a question that goes right with power of attorney that I want to jump in while you're talking about this.
Absolutely.
And someone asked, can a person with a financial power of attorney change asset distributions in your will trust, e.g., if they don't like what your wishes are?
Generally not. I mean, the powers, at least under the Power of Attorney Act in Pennsylvania, allow the creation of a trust, but there's very strict parameters on that it not change the underlying estate plan that the person had in effect, or change the underlying disposition of assets the person had in effect. It's not for them to editorialize. It's just basically allows, now they could change beneficiaries, but again, it's got to be consistent with what the person's intentions were.
Yeah, so I think we're talking so far, obviously the topic of today's conversation is what happens to your money when you die.
Right.
A very big component of this whole process is preparing for what happens to your money when you die. So Ken, can you talk to us a little bit about, we've been kind of putting pieces of this whole conversation together so far, which is pre-planning for when this event happens. When it comes to beneficiaries and accounts, and then powers of attorney, wills, and then we'll delve into, we've been dancing around this topic of trust that we will dig into much deeper as well. But can you tell us about how, a good estate plan prepares all of these things?
Absolutely. I'll start off with what I consider a basic estate plan, because a basic estate plan is much better than no estate plan. And in a basic estate plan, I typically draw 3 documents in Pennsylvania. I do a will. The will distributes, we talked about this before, probate property at death, property with just one name on it, no co-ownership. Because again, the property that has co-ownership and that has beneficiaries on it, the property will pass to those individuals listed. So again, to handle any property that just has one name on it, the probate property, we use a will. We also use a will in the situation where a person has minor children. Because what a will does is a will allows parents to provide for guardianship of their minor children should something happen to both parents, or in a case of a child that is just a mother or a father, and at that person's death, the guardianship provision in a will would advise the court, because ultimately the court has to approve the guardianship, but it's very strong indication of the parents' intentions toward physical guardianship of their child. So very, very important for that reason. The second document we just talked about was a power of attorney, a financial power of attorney, which just covers the situation while you're alive. If you become incapacitated, somebody can sign your name, somebody can act for you. And the third document we've touched on a little bit is a medical power of attorney. The medical power of attorney, same idea. We're going to have an agent appointed that's going to make healthcare decisions for you. Part of the document talks about, tell my clients, keep me alive, keep me alive, keep me alive. I'm incapacitated. Maybe I'm in surgery. Maybe I'm on certain types of prescriptions that I'm unable to make clear legal mental choices for my own benefit. So there's an agent there, a healthcare agent that I appointed, that's going to make decisions to help keep me alive, get me healthy. Now, the other side of that healthcare power of attorney document, within that document is a living will. Now, a living will is basically for end of life planning, end of life decisions. So the living will kicks in a situation where there's absolutely no hope of your recovery. You are incapacitated, meaning you can't legally give consent to anything. And at that point, and there's no hope of recovery. Again, it is the end of life. You're at death's door, and at that point, the living will would kick in, and whatever you would choose in that document, your agent then would be able to effectuate. So what I like about the living will in Pennsylvania especially is that the document allows you to elect, even with the healthcare power of attorney portion of it while you're alive, and the idea is to get you better, allows your agent actually to, if you so designate, to actually go against your wishes in the document. In other words, the document may say, for example, I don't want any kind of extraordinary care if I'm imminently terminal and I'm on death's door. Don't do anything heroic. But your agent, if you so designate in your document, can actually override that decision. Now, in the financial power of attorney we talked about before, you really can't do that in the financial realm, but in the healthcare realm you can. And what's nice about it is that the Pennsylvania document allows for the agent to actually wait and see what happens. And at that point, try to effectuate a person's intent by seeing what the circumstances are at the time. Even if the decision that agent makes is not necessarily consistent with what was written down in your document, allows that agent to call an audible, allows that agent to sort of make sure that the decision is truly something you would want, even if maybe your document doesn't say that.
Great. I know a question that Cory and I get a lot is, okay, no, I have a will. I have powers of attorney. but how often should they be updated?
Again, answer depends. I generally tell people unless a major life event occurs, I like to talk to clients every 5 to 7 years to just hey, is there let's just have a conversation about your family and your circumstances. But yeah, any major life event, for example, the birth of a child, birth of a grandchild, sadly the divorce of a child or a grandchild, maybe a divorce with the client themselves, deaths in the family, deaths of executors and of trustees and of other fiduciaries they've appointed in the document. So I tell people, yeah, a lot of times basic life events will generally be a good trigger to say, hey, look, maybe I should call Ken up and and I have these phone calls all the time with clients. They last a few minutes. It's like you can generally get a pretty good idea over the phone as to, is this something we really should drill down on?
Great, thank you. We're going to take one more kind of presented question to us.
Sure.
And then we're going to try to transition, I think, for the second half of our webinar onto the questions as they're coming in live.
Sure.
From our audience. So we've danced around and broached the subject of trust and the creation of trust as part of an estate plan. Ken, can you tell us, maybe break down when trusts are applicable, when they may not be applicable for someone, and the advantages maybe from taxation, control, all those things that formulate the proper use of trust in an estate plan?
A trust is basically a relationship that you create, that the person that's creating the trust creates. It's a written document. A trust can be its own document, a trust document, or it could be a trust within a will, which is called a testamentary trust document, meaning testamentary meaning in a will. So a trust is just basically something you are writing down to say, I want my property kind of put aside. I want it managed by a person called a trustee. And the trustee is going to manage this property according to the terms that you set forth in your trust document. Typically, I see this happen when a person dies. Say, for example, a husband dies and leaves property to his wife. A lot of times, a person will create a trust under their will to say, I'm going to leave property to my wife, but I want it held in trust, and I'd like her to get the income from the property, income meaning interest and dividends, on a quarterly basis. I'd like to see her get principal. The principal is the money in the trust itself, for health, education, maintenance, and support, generally any good reason. And upon her passing, I would like the property then to either be distributed to our children or to be held in further trusts for children, so that after the spouse dies, the money then is held in trust further. If they had 2 children, half to one child, half to another. And again, some people will put provisions in their trust to say, well, I'm going to have each child get the income from the property to get interest and dividends, and then principal for, again, health, education, maintenance, and support, or whatever they designate. And then some people say at a particular age, I'd like my child the trust to terminate. I'd like my child to get the property, or some people leave it in trust for the child's lifetime. So if you think about it, a trust is just basically a way of controlling the distribution of your property after you're deceased. Now, that's in the testamentary trust type we just went through, the idea that somebody puts a trust in their will, and after you're gone, the trust will dictate what happens to your property after you're gone. Now, there's also a lifetime trust you could create. In other words, they're not just upon death. What you'll see a lot of times is you'll see a lot of people talking about living trusts or revocable trusts. A lot of times, if you go to your mailbox, you'll get invited to a dinner, and there'll be somebody talking about revocable trusts. So that's on the living side of things, and the best use for a revocable trust is a person that really wants to get their estate planning taken care of, would like to do as much as they can toward the administration of the estate on the front end. So a lot of times what I'll do for people is I will create a revocable trust, which revocable means you can revoke it, you can tear it up, and I will create it for a person while they're alive. And what we do is we'll, and what that trust would say, it's a written document, it would say, I'm going to leave the I'm going to put property in this trust, and I'm going to have it in there for my benefit. And if I'm married, I'm going to have it in there for my spouse's benefit. And when I die, I may decide to just have the money stay in trust for my spouse, and on his or her death, I can then have it be held in further trust for my kids. The advantage of putting the property in trust, though, while you're alive, is that now the assets are titled in the trust. So God forbid at your death, there's less to do in terms of administering an estate. We talked about that probate process before. Probate is for assets with just one name on them. If everything is titled in your trust, you don't need to go through the probate process. It's actually all done ahead of time. We create the trust, we title the assets in the trust, and the assets stay in the trust, and we just simply, follow the terms of the trust at each person's death. So it makes the administration of the estate simpler. It avoids probate, it avoids the probate fees and attorney's fees that go through probate. So it's efficient in that sense. And that's a revocable trust. There's no tax benefit to that per se over a testamentary trust or over just a will. It's just more the idea that it appeals to people that really want to get their estate in order. They want to take care of the administration up front so that, God forbid, when they go, they leave as simple an administration as possible for their heirs.
Fantastic. So really, one of the primary goals up front in planning is to try to avoid probate if you can, right?
If you can, absolutely. I mean, it's one of those things that it's just an extra layer of effort that you have to go through when a person dies. I tell people now, the best way I could explain it to people is by doing a revocable trust. You sort of do your administration up front. You put a little bit more time into it now. It costs a little bit more than a will, but by doing it, it's done. And once the assets are in the trust, it takes a lot off of your heirs, the people that you leave behind, in terms of you've left them something that's pretty much done or substantially done in terms of administration.
Yeah, the family's dealing with such grief at that point.
Absolutely.
That the less stress you can add to the situation, which really can create unity and some ease of transition for the family.
Absolutely.
We've seen when this is left unaddressed, it's a stressful time. It can create a lot of conflict, a lot of uncomfortable conversations, and the more this is planned and done up front, the more these problems are avoided later on.
That's correct. That is correct.
Which is awesome. Great. Let's transition to some online real-time questions. So I do have one. We had talked, I guess I would say on mic, maybe off mic, as we were starting our discussion today. And one of the topics was regarding our conversations. One of our questions revolves around the unified credit. So Ken, can you give us a brief snapshot of the unified tax credit and the sunset provision, and maybe share a little bit about your most recent thoughts and findings on the current Biden proposal?
Yeah, there is a state level inheritance tax in Pennsylvania, like we talked about. We're lucky to be one of, I think, about 7 or 8 states that still has one. Not a lot you can do to avoid PA inheritance tax. Now, the question talks about the other death tax, which is the federal estate tax, which is a federal death tax. Now, the federal estate tax, the Pennsylvania inheritance tax, by comparison, you pretty much pay off the first dollar of your wealth. There is no exemption. Everybody with taxable assets pays that tax. The federal estate tax, though, the Internal Revenue Service provides an exemption. So estates under a certain amount or a certain magnitude aren't responsible for paying this tax. And currently, it's $13.61 million, Daryl, is that?
Yes, $13.61
million per person. Right. So a married couple would have $27.2 million of assets that are exempt from this tax, that they would not have to deal with this tax. So right now, it's a very comfortable level. The tax is only paid by, I would consider, the ultra wealthy. However, the current $13.61 million came about, that exemption, by the 2017 Tax Cuts and Jobs Act passed by President Trump and the Congress at that time. Now, there's a provision in that law that says that unless the Congress votes to keep the level going for this exemption, according to the Tax Cuts and Jobs Act, once it's reaffirmed by the Congress, the provision would sunset at the end of 2025 and would revert back to what it was before the Tax Cuts and Jobs Act, which is roughly speaking about half. So even if nothing is done between now and December 31st, 2025, the federal estate tax would automatically revert back to about a $6.7 million exemption. So not as much as 13.6 million, but again, better than it was though. So that's the federal estate tax currently. So it's causing some interesting planning because it's supposed to sunset back to what it was if nothing happens. But the other thing is you have a presidential election coming up, you have Congress potentially coming in, and the law can be changed at any time. If the president and Congress decide to change the law, it can change. So it's become a fluid area of planning, especially for people that are close to those limits, that we need to keep the tax in mind, even if maybe we're not going to be subject to the tax under current law.
Great. Thank you for that. Thank you. Our next question. If the beneficiary in your will is a married child, if she should later divorce, is that money hers or marital property? If marital property, is there a way to protect it when preparing your will so that the money will be made directly to her and not be jointly shared?
Excellent question. The first part of that question I'll tackle. If you were to list a daughter, the question asked, list your daughter as the beneficiary. Daughter's married. As long as you don't put the husband's name on the beneficiary form, it goes to the daughter. Now, the money itself, let's just say it's a $100,000 IRA and you leave the $100,000 IRA to the daughter. That $100,000 IRA is the daughter's separate property, not marital property, but her separate property. Now, if she turns around and lists a beneficiary on that inherited IRA and she lists her husband as a beneficiary, well, God forbid it, at her death, he'd get it because, again, the beneficiary designation always will supersede anything else. Now, assuming the daughter didn't do this, assuming the daughter named her children as the beneficiaries, that would remain her separate property. Now, one thing, though, if she gets divorced, though, while she owns that IRA, the increase in value on that IRA from the point of when she got it at date of death, we'll just say it was worth $100,000, and say at the point where she gets divorced, we'll say it's worth $120,000. That extra $20,000 would be considered marital property in Pennsylvania. So how do you avoid that? Well, the only way to avoid that would be for the daughter, if she's already married, to do a postnuptial agreement so that it would make clear that any of her property, any of her separate property, and the increase in value on that property during the marriage is her separate property. Otherwise, that increase would be considered marital property.
Great insight, Ken. Thank you so much. Next question. I'm going to break this question into, I think, two parts. Cory, I'm going to turn the first part of the question over to you. And that is simply, can a trust be a beneficiary or a transfer/payable on death recipient?
Yeah, I mean, when I think of a trust, it's sort of doing that already. Like you're outlining all of what you want in there. Who's going to receive your assets, what assets each person wants to receive, and then you can add parameters to that on certain ages for folks receiving it. So, I mean, I view it as a way to indicate who you want your assets to go to. I mean, it's probably a more technical question in terms of, is a beneficiary the same as a trust? They aren't the same thing because the trust, you get to like make a lot of details to it. But a trust, is sort of accomplishing what you would try in a beneficiary, but with just more complexity to it, right?
Yeah, I think that's the question and kind of why we're trying to break it into 2 points. Is simply, can you list the trust as a beneficiary?
Oh, yes,
you
definitely.
can. You can definitely do it. Now, the second part of that is where you were kind of going with this question is that the best strategy, or should that be the way it's
set up? I think that gets into the idea of outright versus trust, using a trust. In other words, some people say, well, look, my kids are grown and God forbid when I pass, they're good with money. We don't need a trust. I trust them, meaning I'm going to have the assets distributed outright to each child if they're the beneficiaries and they get the assets and everything's done. It's real simple. Some people say, well, gee, maybe I want to use a trust. And I don't want all that money going to my son or my grandson or whomever. I want to have somebody, a trustee, to basically look after that money. And I want to control the distribution. I don't want it all to roll out at one time to this beneficiary. In which case, yeah, at that point, I think a trust makes a lot of sense because the person who's creating the trust can dictate the points of distribution and the triggers for distribution.
Great. Perfect. Thank you so much. Our next question. Ken, I think you probably get this a lot. I think there are a few layers in this question to address. But I have my estate listed as my beneficiary on all my accounts and my life insurances. And then I have a will. Is this the correct way to handle my assets?
Yeah, let's talk about this. Let's break this down. First of all, with retirement money has certain income tax. Anybody that has a retirement account, if you put money in a retirement account, a qualified retirement account, you don't pay any tax on the growth of that money, at least until you start taking the money out, right? So the same thing works generally upon death. When a person dies, if they list their estate as the beneficiary of their retirement account, all of that money in that retirement account has to come out and income tax be paid on all of it within 5 years. So from an income tax perspective, that's somewhat inefficient. If we were to, for example, name a trust or name an individual, and again, the trust has to have what I'll call certain magic language in it that allows for favorable income tax treatment. But again, if we named a qualifying trust or we named an individual, then we would have 10 years to take that money out rather than 5, number one. And if the individual is a spouse, that spouse can take the money out, or some other designated individuals would have their lifetime. They could take the money out over the course of their lifetime. So with regard to qualified retirement plans, naming an estate as beneficiary, generally, there's a more efficient way to do that. Now, let's talk about the other assets: life insurance, bank accounts, brokerage accounts, real estate. Sure, you could name your estate as the beneficiary of those particular items, and ultimately those items will go through your will, they'll go through probate, they'll be inventoried, inheritance tax will be paid on them because inheritance tax is payable on most things in Pennsylvania. And then at that point, your creditors will be paid from those assets because, again, anything you put into your estate is going to be paid, are assets available to pay creditors and taxes with, and then anything left over is going to go to your beneficiaries. The only thing I sort of pause would be for something like life insurance, naming your estate as beneficiary. Again, you're putting life insurance, you're putting cash into an estate where that money would be used to pay creditors, because if you left it to an individual per se, that money is not subject to your creditors. That money would just go to whoever you list as your beneficiary. So it depends in the sense of I'd want to understand more as to what the purpose for naming the estate as beneficiary. But from a tax perspective, do not list the estate as a beneficiary of a qualified retirement plan unless you don't have any other options.
Great feedback. Thank you. I think this is a fairly standard question, but a good one. If a person dies in Ohio and leaves money to a Pennsylvania resident, is Pennsylvania tax due?
No, Pennsylvania inheritance tax is due on property that is situate in Pennsylvania for Pennsylvania residents. So if you're a Pennsylvania resident and you die and you have real estate in Pennsylvania or any assets like brokerage accounts, anything of that sort, that's all going to be inheritance taxable. Now, if you die in Pennsylvania and you have a piece of real estate in another state, that real estate is not taxable. It's just real estate situate in Pennsylvania. Conversely, if a person dies in another state and leaves you property and you live in Pennsylvania, the taxability of the estate is determined by the decedent, not by who receives the property.
So wherever the person that's residing, whatever their state of residency is, that's where the estate is settled.
Correct.
And that's the state tax that's due.
Correct.
Oh, perfect. Great. Thank you for that.
And that's probably why folks will move to Florida in some cases, like from PA, right? To avoid that state inheritance tax, get residency in Florida, and then you don't owe that upon your passing.
That is correct. If you could become a resident of Florida, your estate would no longer be subject to the Pennsylvania inheritance tax because you're not a resident of Pennsylvania anymore. The only thing that would be subject in Pennsylvania would be any real estate physically situate in the state of Pennsylvania.
Great, thank you. What if you don't have anyone to name as an executor? What is suggested for this situation?
If you don't have an individual, what I like to tell people are to use a trust company. For example, most banks have trust companies. Most brokerages have some wing or arm or relationship that's a trust company. For example, you folks have several relationships, do you not, that are in the trust realm?
We do.
Yeah, and by naming a trust company, the trust companies are good at it. They're insured for it. They're very experienced, and they do a good job in the sense that that's their business. And when you name an individual, you want to name somebody you trust. And if you don't have anybody that's that close to you, I wouldn't just go name a stranger. I would name a trust company before I would do anything else.
Wonderful, thanks. So I guess this is probably for a timeout. Takes it is warranted to just say, in this situation, if you're a client of Fort Pitt or any brokerage house or any firm, you should ask your financial advisor. They generally can guide you in the right direction and have contacts of people and can make a recommendation or referral to someone who they know will do a good job at a good price.
Absolutely, yes.
So a great place to start. If you don't have anyone, see your financial advisor. Let me capture another question. What is the average cost for a basic estate plan of the 4 documents you mentioned?
I mean, that's going to vary by attorney. Generally speaking, I charge a flat rate on those documents. I've really gone to flat rate planning lately. I'd say within the last 5 years. I don't want clients to be looking at their watch. I just want the job done right. I want everybody to be comfortable. I want to have the discussions we need to have, make the revisions we need to make. For something that's a basic estate plan, I charge $1,000. Again, that's not an official fee. I'm sure if you talk to 10 attorneys, you might get 10 different prices, but you want my price, that's my price.
Well, we see this out in the marketplace, in the landscape, and that's a good price. It's a great value. Wonderful. Based on the description of the revocable trust, why would someone choose the testamentary trust over the revocable trust?
It's simpler. I mean, if you think about it, with a testamentary trust, you have 3 documents. You have a will, power of attorney, general power of attorney, and a healthcare power of attorney, living will. With the revocable trust, you have 4 documents. You still have a will. The will is called a pour-over will because the will is basically designed so that if we missed any assets, or if we didn't title everything into the trust, or if 5 years from now you go and open a bank account and you forget to title it in the trust, the will directs all of those kind of stray or orphaned assets, all of those probate assets that we really didn't intend to have, but in case we do have, the will's there to direct them right to the trust. So you need to do a will, so you need to do an extra document. And then once we do the revocable trust with all of the provisions in it for the who gets what and when, and how distributions are made, we then have to go the extra length, and we have to make sure we get assets titled into the trust, ownership of these assets put into the trust. So we've got to go through asset by asset. If it's real estate, we've got to do a deed. We've got to deed the property into the trust. It's a lot more work. There's considerably more work involved. That the fee is, as a result, higher. And some people are of the opinion, they're like, look, I just want to do a simple will. I'm not worth $27.2 million, not even close. I don't want to have to mess around with all this, all these other documents, all this extra time and money. I just want to do a basic set of documents so that, God forbid, at my death, everything goes to my wife, everything goes to my husband, whatever it is, and then ultimately it goes to the children, either outright or in trust. You can do all that through a testamentary trust document, testamentary will, and it can be done a lot less expensive, and it can be done with a lot less just steps, a lot less things to do. So that's generally why people will do a testamentary trust over a revocable trust, is simply they don't want to get into all the weeds of getting the estate administered now. They're just, we'll worry about that, God forbid, when I pass.
Ken, thank you for that. That's fantastic information. This is an interesting question. Can a trust be created in another state for more favorable tax treatment?
Yes and no. Yes, in the sense that there There are some jurisdictions that actually advertise this. There used to be something called a rule against perpetuities, which was basically a rule from England back in medieval times, how long you could hold property in trust. And you lined up 100 lawyers, all 100 lawyers would give you a different answer as to what the PA rule against perpetuities would say. Now, about a number of years back, I forget how many, Pennsylvania abolished the law. They got rid of the rule against perpetuities. So now you could hold property in Pennsylvania in trust as long as you possibly want. A lot of, before that law changed, though, a lot of these jurisdictions would advertise. They would advertise, well, gee, we have no rule against perpetuities. You could hold property in trust in our state for as long as you want. Other states advertise the fact that they have very favorable creditor laws. In other words, you can put property in a trust in our state, and it's harder for your creditors, God forbid, if your creditor gets a judgment against you, it's harder for them to get at your property. And again, you can do that. Now, there are some requirements, though. It would depend upon state law as to what minimum contacts you need with that state for it to be considered a valid trust. But yeah, generally speaking, you can create them out of state. There are certain things required. Sometimes you have to have a like a local trust company as the fiduciary. Some of those laws are written so that you have to have a trustee within the state. But again, subject to those minimum contact laws, yes, you can create a trust out of state. Sorry, the judgment, the jury's out as to whether that provides you real asset protection. That's why people create them. They create them for asset protection purposes. For tax purposes, not so much, because if you're a resident of a state, you're going to be taxed in that state, whatever that state's laws are. By creating a property, if you created a trust outside of Pennsylvania, you're still going to be income taxable on that trust, even though it's in another state because you're a PA resident. So a lot of times it's not for income tax consequences people do it. People generally do it for creditor protection, I see. That's generally the main reason why people would do something like that.
Great, thank you. I think this is more of just a logistical, legal question, law question. Is a judge assigned to handle the probate stuff?
It depends. When you go through the probate system, initially there's no judge. It goes through, at least in Pennsylvania, it goes through something called the Department of Court Records, which used to be called the Register of Wills. And it's an administrative office. You go in there, you slide the will across the counter, you pay the fee, they have the executor raise the right hand, and they swear the executor in under oath. And if that occurs, you then get these documents called short certificates, and you use those documents to go out and gather all the assets. And largely speaking, in Pennsylvania, the executor can administer the estate, or in case of an intestate estate, the administrator can administer the estate largely without court supervision. The beneficiaries all agree. The beneficiaries can all agree to close the estate, and I would say 95% of the estates I've ever handled never see the inside of a courtroom. Sometimes, though, people choose to have the estate reviewed by a judge. In other words, that process is called account and audit. The executor at the end of the administration creates an accounting, and the accounting is basically what came in, what came out, what's left, and here's how we're going to propose to distribute it based on the terms of the will or based on the terms of intestacy. And a judge would review that accounting, and beneficiaries would review that accounting, and then the judge would, in essence, in open court, would ask the executor some questions, ask the counsel some questions, and would then close the estate. So some people choose to do that because, again, it's a more formalized process of closing, and once the estate's closed, it's closed. Sometimes, though, there are disagreements. Sometimes you basically have a beneficiary, or there's a controversy of some kind where litigation ensues, and at that point, where there's some sort of a litigation activity with the estate, either by beneficiaries or creditors, that's when a judge would be assigned to handle the case. Now, in Allegheny County, I don't know exactly how many probate judges there are, but if there are multiple ones, they would be assigned. They would have a system for assigning. I think Butler only has one probate judge that I know of that would get the case. So it would depend upon the county, but again, that only comes into play if there is a dispute.
Great information. Thank you, Ken. We have time for one more question. I'm going to maybe rephrase this a little bit, but the core of the question is, you have a trust and designate a special needs fund for a disabled child. What are the specifics around such a fund? Or can you just share some general best practices around special needs trusts?
There are two different things going on in that question. When you have a disabled beneficiary, there are these things called special needs trusts. They're creatures of both federal and Pennsylvania law. And what they basically say is there's a certain requirements for this type of a trust, but basically the idea is, look, I have a special needs child. I want to leave money to him or her. So I want to leave money in a trust, but I don't want that money to affect the child's ability to qualify for public or private benefits, such as medical assistance in Pennsylvania. So by going down the special needs trust route, that trust is there for the benefit. It's to supplement but not supplant or replace those benefits, the medical assistance that the child receives. So it's there for other things for the child. And again, there's a set of rules as to what is or is not permitted in terms of withdrawals for the child's benefit. Now, at the end of the child's life, whatever is left in that trust then would be subject to the claims of medical assistance. In other words, there would be recovery for monies spent on that child's behalf from the monies in trust. The purpose of the special needs trust is to leave property to a child so that there's an abundance. There's extra provision made for that child's well-being, so that if any of those funds remain unspent, they're then used to pay back the state and federal funds that were used for the child's care. That's one version of the special needs trust. The other version is called a supplemental care trust. The other version, it works a little bit differently. The other version is you create a trust and you say in the trust, again, I want this money to supplement, not supplant or replace medical assistance and other benefits like that. But by creating that trust in Pennsylvania and providing in that trust that the trust is not to be used to affect the beneficiary's qualification for these benefits, such as medical assistance. And if the trust is administered properly, the funds in that trust can be used for the child, for trips, for computer, for any kind of enrichment other than what medical assistance would normally pay. And the difference between that and the special needs trust is the supplemental care trust would pass then to whoever the other beneficiaries are you designate after the child. Now, why would somebody choose one over the other? The special needs trust, as long as you stay within, and they're very, very difficult, I shouldn't say difficult, but very specific parameters of what you're allowed to put in that trust, you have a certainty as the parent or the person leaving the property that that money's going to be there for the child, that money's allowed to be spent on a certain laundry list of things, and that the government will not contest it. There'll be no litigation in terms of, well, we don't think that this trust is properly set up and we want all the money in the trust immediately, and none of that will occur. So you have the certainty of the government leaving you alone and leaving your child alone. And upon the child's passing, whatever funds are in that trust, pay back the government for what they've spent. So it's a very ordered process, and you have certainty that the money will be there for the child while the child's alive, subject to the requirements of the special needs trust in general. Versus the supplemental care trust is, basically you're creating a trust for this beneficiary and you're saying, look, I don't want it to affect the beneficiary's qualification for federal benefits or state benefits. And at death, I want the money to go to somebody else and I don't want the money to pay back the government. The government can contest that trust. Now, the Pennsylvania Supreme Court has approved the use of those types of trusts in several rulings, but there is potential jeopardy in terms of the Department of Public Welfare, for example, contesting the trust, saying, well, wait, no, this is no good. We're going to use all that money first before we pay the child a dime of medical assistance. So it's an area that's it's more financially beneficial for whoever the remainder beneficiary of the trust is, because they would at least get the unspent funds. But that trust can be contested by the Department of Public Welfare, versus the special needs trust cannot, as long as you stay within the boundaries of that type of trust.
Awesome, great. Well, guys, that brings us to the end of our webinar for today. I hate to see our discussion. And Ken, thank you so much for joining us. You shared such great information and a wealth of information with us today. So for those of you who are interested and want to hear more from Ken, Don't forget about our May 7th event, Smart Inheritance, again, May 7th at noon. Ken will be back to share more of his knowledge and expertise. Cory, thank you,
Thank
for
you.
your piece in this webinar as well. And with that, we all want to say thank you for joining us. Have a wonderful afternoon. And if you have any questions or any follow-up items, as Cory mentioned earlier, please see your financial consultant at Fort Pitt Capital Group. We're happy to dig deeper into these discussions and help you reach your financial goals and objectives. So thanks so much, everyone.